Hello, everyone. Thank you for joining us today for another Trust Education webinar. My name is Kurt Kohler, and I'm a trust consultant here at National Advisors Trust Company. Today's presentation is titled Special Needs Trusts, Planning for Individuals with Disabilities, and is presented by the Executive Vice President and Director of Personal Trust for Cannon Financial Institute, Daniel Smith. During the presentation today, please feel free to submit any questions you have via the chat box. You can simply click on the icon at the bottom of this meeting window that says chat, and the chat box will pop up on the right side of your screen. Daniel will address any questions you have as you submit them. Please also make sure that your line is muted during the presentation. You can find this function on the bottom left-hand side of your Zoom window. A final note before we begin. Following the webinar, you will receive an email that will instruct you on how to file your CE credits for attending today's Trust Education webinar. That email will also include a PDF of today's presentation slides. So again, thank you for joining today. I hope you enjoy the presentation. And with that, I will now hand it over to Daniel.
Thank you, Kurt. Glad to be with you all again. We're talking today about a particular type of irrevocable trust, a specific type of complex irrevocable trust called a special needs trust, or sometimes a supplemental needs trust. And it's really important to understand that, and we'll review this concept, that this is basically the same kind of trust that we've been creating as a bypass trust or a dynasty trust or whatever else. It's going to have very specific language in it with regard to how distributions can be made. Basically a very restrictive, ascertainable standard defined in the trust. And that's really one of the key things that makes special needs trusts do what they do. Several different ways to get into them. Certainly we don't need to be the experts on all the ins and outs and details. That's why we depend on people who administer these things for a living to understand all the ins and outs, a lot of which are related to state law issues. And so that differs from state to state. I have a hard time answering questions about that because the rules differ from one state to another. But the concepts behind special needs trust are very consistent. One of the big things we want to separate between is whether it's a first party or a third party special needs trust. So just looking at sort of our objectives overall, obviously there's a lot of people who can't take care of themselves or protect themselves and therefore need to be the subjects of planning. This might take place in a proactive way, either by the courts or by the client themselves, or by the client family. Generally, it's going to be one of those three groups that is operating in this manner. So very important whether those issues are things that we knew were going to be an issue in our planning, or whether they're things that have come up as a result of an accident or injury or something else that has happened along the way. Sometimes we even want to morph an existing trust into a special needs trust. And we can talk a little bit about how to do that as well. So again, first party versus third party trusts. We'll talk about basically first party means I created it for myself. Third party means somebody else created it for me. We'll talk some also about examples of appropriate expenditures. Obviously, this is an area where there's differences in some of the state and federal law programs that are out there. And these are things that people who specialize in administering these things are very cognizant of. I've got a substantial list, including the materials, of things that we know are safe distributions with regard to the plan itself. We'll talk a little about the clawback rules, which basically apply to first-party trusts as opposed to third-party trusts, and also, as I said, modifying existing arrangements sometimes so that they meet the standards necessary to do this. It's one of the substantial uses that I've seen of decanting, moving money from one trust into another trust, so that trust has different distribution provisions or other aspects to it that drive the process. So just to understand how big this area is, the American Community Survey estimates the overall rate of people with disabilities in the U.S. population is about 13.2% in 2019. Obviously, it takes a while to compile some of those statistics. The percentage of people with disabilities in the U.S. Rose over the last 10 years from 12.7 to 13.2. So this appears to be an increasing element of the population, and as a result has driven a great deal of interest in the area of special needs trusts. Also, their complexity really drives, I think, a desire for people to have these in the hands of professional trustees, people who can keep up with the rules and who specialize in these areas, because for the individual population to understand. Number one, there might be family members, there might be conflicts of interest associated with that wouldn't otherwise apply, because the way the expenditures are made, those expenditures can not only benefit the individual, but sometimes inadvertently benefit the family themselves. And so these are things that we want to be careful with regard to these types of trusts. Also in the US, rates of disability increase obviously with age. So for people who are substantially older, the same kind of group that would be at highest risk of COVID and other things we've seen recently, this is going to be 33.8%. Once you get to age 65, there's about a 50% or greater chance that you'll have at least 6 months of disability somewhere before someone passes away. But look at 18 to 64, we're still talking about 10% of the population. That's a substantial portion of the population that needs to have some kind of protection associated with this. And by the way, I've tried to add sources in all these things so that these are areas that you can go to and keep up with on your own as numbers change over time, if it's an area that you're working in with people. But planning for people who have families that involve someone who needs some kind of financial care is an area that has existed for a long, long time. The rules have gotten more specific, and I think we're getting a better idea of exactly how to operate within these spaces, within the planning structures that are trusts. I was involved in a lot of these that were actually created by the courts, because there would be an accident and there would be a lawsuit as a result of it, and there would be a finding and a judgment of a lot of money. And the last thing in the world the judge wanted to do was to put that money into the hands of a family directly who was caring for that child, but who could also misuse that money. That is to say, they're not all necessarily families who come from high educations or dealing with large amounts of finances. And so the conflicts of interest can be substantial. We've seen that even with kids who are excel at sports. Take the positive side of that, people who are doing really, really well in life, or successful childhood actors or things like that, and their parents naturally, as their natural guardians, manage their funds, and sometimes that leads to potentially disastrous results because the conflicts of interest that come up involved with that, and the fact that the parents aren't necessarily financially trained, and so they don't necessarily know what's right and what's wrong. They're often doing what they think is right. There's great rationalizations along with that, but we can look back at some of those things and realize that they were fairly abusive in terms of the way that they operated. And so this is one of the reasons why working with a neutral party can be a really important part of that process, so that you really have that neutrality in looking at what's going on and making sure that we're acting in the best interests of the individual who is involved. So obviously this doesn't only affect the disabled individual themselves, but also their caregivers. Payments for things that people are doing and their caregivers, again, are often family members who are involved in the process. So, the current needs of the loved one have to be taken into account. But to the extent possible, the changing benefit landscape, service delivery, in which that individual in the community is taken care of, we want to make sure that the money is used in the most appropriate fashion. In 1993, OBRA is a tax act back in those days. Congress allowed for the creation and funding of a class of trusts. So there are, instead of just individually crafted trusts, you can have pooled trusts. You can have what we typically refer to as special needs or supplemental needs trust, qualified income trust. So there's different structures that can be created with this. You've probably heard of ABLE accounts. Each of those things can be obviously discussions in and of themselves. We want to talk about the broad overarching method in which these things work. But this allowed for the creation and funding of these trusts without adversely, that should L in there, affecting the Medicaid eligibility of the beneficiary. Medicaid, of course, is the safety net program that the U.S. government has in place, that if somebody is financially challenged, that they have a safety net to be able to go to. So it's essentially part of the welfare system in terms of taking care of that individual. So the debate comes up, when an individual has their own money, to what extent should this Medicaid system be playing in? Because of course, Medicaid doesn't pay for everything. And so it pays for essentially medical services and the things surrounding what the needs of that individual are. But those needs aren't necessarily what you and I would consider to be all the life needs of that individual. So supplemental needs trust or special needs trust is a discretionary trust. So it's always going to be a complex style trust. We don't ever want all the income automatically to pay out to the individual. It's always going to be a discretionary trust. to provide, obviously, for a disabled individual with benefits that are not otherwise provided for by government benefits. And that's the key thing. That's the key differential here between other types of irrevocable trusts that are complex trusts trying to take care of family members in the same way. They can have very broad descriptive terms in terms of how things are to be paid out, whereas the language in a special needs trust is generally kind of very specific language. For instance, the trustee shall not make any distributions from this trust that would disqualify the beneficiary for state or federal aid program. So you can imagine we're very, very careful in terms of what the distributions are, how the distributions are made. In all irrevocable trusts, that's an important component, but here you're actually talking about the potential for disqualification from other kinds of benefits. And so it's a really, really important thing to make sure you understand and get right. Whereas if I over distributed from another kind of trust, I can cut back in other ways. I can change my distributions in the future. Those are things that are not going to punish us in some other manner or disconnect the value of the trust itself. So generally the principal is protected and therefore not counted as an available resource for eligibility purposes. For these purposes, if the trust is set up in a way that is deemed to be a special needs or supplemental needs trust, then that's not deemed to be the individual's assets. We'll talk about the clawback feature later on. The beneficiary can continue to receive SSI, Medicaid, or other state, federal, local programs without any interruption, even though there may be an additional resource available to them through the auspices of the trust itself. So essentially, there are two different types of special needs trusts. This is one of the key things for us to be able to understand about this is what is the source of the money, right? Where is the money coming from? Is it coming from the individual themselves? So if I have a self-settled special needs trust, self-settled meaning it's my money and I'm setting up the trust for my benefit. So for example, I become incapacitated tomorrow. I have some sort of an accident. I have some assets built up already in my own name, retirement assets and individual savings and those kinds of things. To what extent can I protect those assets from being used for my medical care and treatment versus utilizing the Medicaid program to do that? Obviously, those assets sit in my individual name. Naturally, they are resources available to me, and therefore those assets will disqualify me from any kind of welfare program that would otherwise be out there. So I can take those assets and put those assets into a trust to provide for my supplemental needs and still be eligible for the program. Talk a little bit more about this as we go along. But this is where the government does want to reach back and say, all right, so if we paid for a lot of the services that you had available and you had other resources available, granted you want to use them for other types of purposes, when that person passes away, basically the state's going to say, we paid that money out for your care. We would like to get that money back to the extent there are still assets inside of that trust. Okay, so this is what we refer to as a first party trust or self-settled special needs trust. The second part is a third party special needs trust. This is where my parents recognize that Daniel, doesn't really have the capability to manage his stuff himself. And therefore, we're going to make sure not to enrich him in the first place. We're going to set those assets aside, not give them directly to Daniel, but instead put them into a special irrevocable trust for benefit of Daniel, right? And so this is where we're going to get our great separation, the tax protection, asset protection line between those two individuals, and we're going to set up a third-party special needs trust. So this is where the concepts that we've talked about before in many of the classes that we've been in, the various kinds of trusts that come out there, all play into the process, and you get essentially the same effect, right? We're not leaving the money to the beneficiary, we're leaving it for benefit of the beneficiary, and this irrevocable trust arrangement. So that's incumbent upon us as advisors, obviously, to collect information that will be valuable to the people doing the planning or structuring the arrangements, to understand what are some of the key things that play into this arrangement. So let's talk about what some of those factors are. Obviously, we need to know about the person and their relationship and their age, right? The relationships of the different parties who are involved in this arrangement. And people aren't always really forthcoming about this. I think a lot of people are not fully aware, especially in a lot of wealthy families that I've worked with. They have the ability to pay for themselves, and so they often just pay the bills. And that's an absolutely fine way to do it. If you ever saw the movie Rain Man, that's essentially what his father did. Rather than having the child live in some kind of a welfare state through a Medicaid type of program, he left his money to the institution in which his child would presumably always be housed. So from a functional standpoint, if you have the ability to pay for yourself and you're perfectly willing to do that, I don't need to go through the rigmarole of doing this. But a lot of people are not aware that even if I'm from a wealthy family, I may have the ability to set that money aside in a way that it can provide supplementally for those needs, right? Most people have unlimited amounts of resources to be able to pay those things. And so the fear is that my other money will run down, the welfare programs will kick in, but it will only pay for the minimum benefit that the state actually provides. And so we'll talk about some of the other kinds of things that can be paid for in this and why this is such a good idea to be able to put in place. And so that's why we really have to understand what are the relationships between the parties involved. That oftentimes doesn't come up directly in conversations. And so you have to listen for clues when you're talking about stuff. So, I like to use family groupings and individuals. And, when they say they have kids, and I say, great, how many kids do you have? And usually the way I'll do this is I'll simply put it into context. So let's just take a really simple example and say that my client has a net worth of about $4 million. And I know that they have 4 children. It's important to keep this in context so that it doesn't seem weird to them where you are dollar-wise. So if I'm going through a conversation with them, gathering up information, updating their assets and where they are, I say, great, we have a net worth of about $4 million. And you have to tell me about your estate plan. Their estate plan leaves things equally to the kids, for instance. And so you can say, so tell me, if you gave each of your kids $1 million tomorrow, what would they do with it? This is what a lot of people's estate plans essentially do, right? They simply distribute the money outright to each of their kids. And so I like to ask that question directly in that way, because it's an indirect way of getting the feedback. They'll generally answer child by child. Well, my oldest child, he'll probably have it spent within 2 weeks. Now my daughter is the second one, and she'll have every buck of that saved and be earning interest on that going forward. My third will probably speculate like crazy, and who knows whether he'll make money or not make money on that. And my fourth really, he doesn't have the ability to manage that money himself. Some kind of information is going to come out. They won't necessarily.
Hi, Brianna, this is Patricia Kummer, Kummer, returning your call to schedule an appointment for an ultrasound from Roger Merkin over at Panorama was the referral. So if you could please call me back so we can schedule that, I'd appreciate it. 303-909-4091. Again, 303-909-4091. Thank you.
Thanks, Patricia. Might want to find that mute button, just a suggestion. All right, so from there, that's where you oftentimes get information flowing out from the client that is going to give you some indication that there is some kind of a family issue, that somebody is unable to manage the money directly themselves. Again, people don't just lay that out on the table necessarily. Sometimes you have to draw it out from them. And so it's an important thing to take a look at. And so from there, you say, well, tell me a little bit more about that. Well, Daniel was born with a developmental disability or something like that. And trying to figure out what kind of disability that it is. Is it developmental? Is it physical? Is it mental? Is it just medical care? Oftentimes people have complete capabilities to process information, but they need help with other kinds of medical care. And so the key thing I'm trying to figure out is the child involved in the process? Do they understand what's going on? Can they be a participant in that process? Or are they somebody who needs to be taken care of completely? And so those kinds of things can certainly affect the structure and the way that the structure gets set up in the first place. And then also just thinking about what is it that precipitated the meeting? Why are we having this conversation in the first place? Obviously, that's one thing that I try to initiate with other clients, but oftentimes I get young couples coming in, and anytime a young couple especially is asking about estate planning is one of the first things that they're keyed in on. I always ask, what is it that made that come to mind for you? Oftentimes it will be a death in the family or some kind of a dramatic event that they have experienced recently themselves. I remember talking to one couple and they said, there was the woman said she was driving down the highway at full speed, and suddenly, as if she had slammed on the brakes, but she said she didn't, at full speed, at full highway speed, the entire car locked up and spun around on the freeway, where all the other cars, of course, were going full speed straight at her. And she realized, you realize this stuff could happen to you at any time, and I better have some kind of plan in place. And so just kind of understanding what that is, whether this is one of the key reasons for the meeting, the fact that they have a special needs child and they wanted to talk about that, that will usually come up, obviously, in your setup to the meetings, or whether this is just kind of a background element. Well, again, a lot of people don't know how to bring that up or even know that there are special issues that can be addressed within that arrangement. You also want to identify whether there is a litigation or settlement position that is taking place. In other words, was there a lawsuit? And as a result of that lawsuit, there is money coming available to a child, and they're trying to figure out how to deal with that. In the same way that a lottery winner in a surprise manner, winning the lottery, needs to do a lot of financial planning to try to figure out what am I going to do with this money? How's the best way to protect it? How should I invest it? How should I take care of those things? My child may have been through a difficult situation, or I might have been through a difficult situation or an accident, and there may be someone at fault. And as a result, we're going through a lawsuit. Initially, I don't know whether there's going to be a finding of fault or not, but now as we're sort of winding our way through the process and talking about settlement agreements, we've got to figure out what is the result of this and who is the money coming to and what are the reasons for the remuneration that's taking place. Is that to the individual? Is it to the family for what they've experienced? Those components of it are important with regard to who is the owner of the underlying funds. And then we have to get into a little bit the government benefits. What government benefits are currently available to those individuals? Again, you don't need to be an expert in the area and understand all the individual pieces, but what kinds of things are we looking at here? We're looking at Medicaid and the services that can be provided in a situation like that. We're looking at residents, a group home, or care facilities. They can stay at home. How are the manners of residents going to be addressed? And then education or work. They have supported employment, is there sheltered employment or developmental training that people are handling? I've got special needs situations in my own family. My younger brother is very high functioning. When he was young, we didn't know that he would be able to operate on his own and hold a job, but he's married and has a job and is fully employed in the regular workforce. That was not an easy climb necessarily for him to go through, but from a functional standpoint, he was able to work his way out of the issues that he had and develop a level of education necessary to do work and participate regularly in society. I have a niece, however, that will never grow out of the condition that she's in, and so she has supported employment. She has the ability to do some things, but not in a way that's going to be able to be supportive of her. But nonetheless, activities, social interaction, work interaction, keeping busy both physically and mentally, those things can be really, really important. So kind of understanding what does their situation look like in that way. Those are important things to explore as well for people who are involved. If they haven't looked at that so far, just exploring a little bit of what they would expect along those lines. And then from a financial support standpoint, where does the family come in? What is their current and potential future contributions to being able to support this child? Growing up, for instance, my parents and I, we all had wide open conversations about that stuff because my parents didn't want us to be surprised should something happen to them. There's 4 of us, and to make sure that we all understood clearly ahead of time that their estate plan was set up primarily for Duncan, right? Once we were all adults and had full educations and had the capability of supporting ourselves, obviously he was the one that might not be able to do that. And therefore, things for a long time were set up primarily in his benefit, completely understandably. And when families have conversations, open conversations about that kind of stuff, it keeps that kind of issue at bay. People understand what's going on with regard to that, where the funding is coming from, why things would be structured in the way that it is. Also the work of the individual. So as we were talking about before, if they're able to work some and provide some for their own financial care, obviously that's money, first party money of that individual's work that they're doing themselves. That is money they might be able to put into a special needs or supplemental needs trust, or that would just cut down the amount of benefits, count towards the benefits that they're receiving from the state or federal government, and then what government programs might be available to them. Again, both state and federal level can be quite layered, and the rules are different from a state to state basis. But in a lot of cases, they may require a special needs trust, especially if funding is being made available to that individual. Again, if I got into an accident today, right, I'm later on in life, I've built up some assets on my own. The question is, how would we best protect those assets that are there? As opposed to, I'm thinking about a minor child, I'm thinking about somebody who's under my care, and I'm trying to figure out when I pass away, what's going to happen? How do I continue that care without that money simply being drawn away purely to medical care that can be quite expensive and no longer be available for other kinds of supplemental needs of that individual. So as we look at estate planning options for a special needs family, let's just talk about some of the key elements that are here. Number one, distributing assets outright to the individual with a special needs child. This is not something that you necessarily want to do, since the assets may disqualify the child from receiving means-tested government benefits. It is really important that when this is recognized within a family unit, that you create the proper asset protection arrangements to be able to do this. So even a grandparent leaving money to the children, where those individuals have a special needs child, that's something you might want to instead look at putting it into an irrevocable trust instead for benefit of those parties, so that we keep it behind the asset protection wall. Disinheriting the special needs child, right? This is generally not recommended because this child will have no safety net if the government benefits are subsequently reduced or eliminated, right? Some people just say, well, Daniel is subject to state or federal aid programs, and so we just won't leave him any money, right? If we got 4 kids, Daniel's would simply go to the government essentially, and so we're just going to disinherit him from the assets that would be passing down within the family tree. The problem with that is all you have now is the government benefits available to that child. Now, you might get promises and willingness of other parties to be able to support that, but now you have hope rather than a plan. And so it's really important to understand what level of planning you want to engage in to ensure that that child is taken care of, properly taken care of, structures are put in place to be able to care of them in a way that those assets are available to the child, but not necessarily going to disqualify them from the government benefits that would be otherwise available. Third thing is you leave property to another family member with the understanding, right? The quotes in here. This is the hope as opposed to plan side of things, that the property be used for the benefit of the special needs child. So it's sort of a moral trust or an honorary trust. Again, generally not recommended since the arrangement isn't legally enforceable. And the creditors of the family member, including ex-spouses, somebody could get divorced, or those kinds of things that could have substantial implications, or if I were to get involved in other kinds of legal issues, I was drunk driving or something like that, I had an accident, those are my assets. And so if I'm the caretaker and I'm the person who's supposedly going to be using my assets for somebody else, those assets are subject to the creditors of the caretaker inside of that arrangement. Of course, you don't have that problem when you're dealing with an irrevocable trust instead. So very important to make sure that those assets are protected in the manner in which the family feels most comfortable. Number 4, you could establish a third-party discretionary support trust for the individual with special needs. This is something to be careful of, right? Generally not recommended, since the trust will, in many states, disqualify the child from mean-tested government benefits. If I just have an irrevocable trust for benefit of the child, right? Just a regular discretionary support trust, not a special needs trust, but just one that says, pay so much or all of the income and or principal to my child or children, or my descendants, right? Standard language that we see in the trust and estate planning world. So what we think of normally as a bypass trust or a dynasty trust type of setup, where we're using something that has an ascertainable standard language in it, the typical language that we might see, like health, education, maintenance, or support, right? The kind of language that is typical in the trust world to use may be perceived by the government and the courts as being so generous as to being available to the child, right? Even if not owned by the child, but nonetheless under those clauses, if it says health, for instance, or maintenance and support, for instance, that those assets would be deemed to be assets available to the child and therefore disqualifying. So this is where, let's just call this a normal irrevocable trust might sound like it's the panacea for things. And in fact, that might be the normal part of my estate plan that was set up when I don't know that there's going to be a special needs issue with regard to a family member downstream, a child, a grandchild, et cetera. And this is where we might want to morph or decant this trust or modify this trust so that it complies with the special needs rules. So number 5, establishing a third-party created and funded special needs trust for the individual with the special needs. This is really the direction that you want to go, since the trust will not disqualify the child from receiving means-tested government benefits, right? It has to have specific language in there. It's going to be identified in that way. So when we have very broad ascertainable standard language as the trustee deems appropriate, or Health Education's Board of Maintenance, or in their accustomed manner of living, right? Language is very typical in the irrevocable trust world and normally serves as a barrier to entry to creditors and other types of parties. But it's not going to protect me if it says that it's to pay for my health. And sure enough, these are healthcare services that I'm receiving. And the government's going to say, we're not going to pay. Obviously, they don't want to pay for anybody who can pay for themselves. And so this is a really, really important balance to strike inside of this arrangement, and to realize that sometimes that irrevocable trust that is created with all good intentions and is proper planning in a regular family situation, you might want to take number 4 and decant it or modify it so that it becomes a number 5. Again, this is a very specific methodology in the trust world to be able to take essentially the contents of one trust, put it into a context that most of us can understand, and decant that into another trust, right? So if I've got a bottle of red wine here and I pour it down into my decanter, then I've changed the structure, but not so much the content. In the process of doing that, I can also sometimes change the beneficial language inside of that arrangement. The legal context here is that if I can distribute from the trust, right, if the distribution language allows me to distribute to Daniel, right, for my Health Education Board of Maintenance, for my custom manner of living, for whatever the language is in the trust, as the trustee deems appropriate, then presumably I can distribute to Daniel in a lesser form. That is to say, into a trust for benefit of Daniel that has more restrictive language than before. Again, in fiduciary capacity, I have to be able to identify that I'm acting in the beneficiary's best interests. That's sometimes harder to do if you're just talking about Daniel as a regular person. But if you're talking about Daniel as a special needs person, now that starts making a whole lot of sense. And there are lots and lots of case law out there on decanting as a result of let's say a child reaching the age of 18 or 21 or 30 or whatever the trigger age is inside of the document, right? Very often I'll create a trust and I'll say, if my kids are under the age of 35, then hold the money in trust for their benefit. And when they turn age 35, give them their share of the trust. Well, so if I'm 34 and this trust pays outright to me at age 35, and it's clear at this point that I have developmental disabilities and I'm not going to be able to handle those assets on my own, then before the outright distribution takes place, before that trigger age occurs, it is important to get those assets from the irrevocable trust that is behind that asset protection firewall and put it into a trust that is protected because of the special needs rules in the code. Very, very important to understand the timing of that. Because if I get to age 35, then it's an outright distribution to me, right? I have full control of that. If we wait until that event takes place, it's going to mean that even if we do create a special needs trust, it's going to be a first party trust instead of a third party trust. It is better to create a third party trust instead, right? So a third party trust is going to be the one that we can protect the most from this arrangement. So that decanting from one arrangement into another should take place in advance of lifetime general powers of appointment accruing, or outright termination or distribution language taking place inside of the trust, right? It's an anticipatory arrangement. So when, again, you have family members who have issues asking about, are there trusts that have been set up by the parents or grandparents or other parties for benefit of that child? And so that we're anticipating those periods where that money would become available to the child outright, and therefore would be the child creating the structure effectively rather than the parents creating the structure. Even if the parents are doing it as guardian of the child, right? They're doing it on the child's behalf with the child's own money, and therefore it's a first party structure instead of a third party structure. So that's really the direction that we want to go inside of those arrangements, even though the regular planning that we've talked about is a good idea. And I don't necessarily have to have every alleyway created. I do see sometimes that there will be specific language inside of the trust that says if any beneficiary is not able to handle the trust, then the trustee has the ability to, or it will define a separate route to go down if child's unable to handle the assets on their own, or they'd be subject to state or federal aid programs or disqualified from state or federal aid programs, then distribute the money as follows, and it will go down a different route and create a special needs trust within that arrangement. Not necessarily default language, right? Because when people don't have those situations in their family, they're not necessarily anticipating those situations within their family. So very, very important to understand the balance of that, and that what is sometimes normal, very good planning may not work in a context like this. We'd rather not have to go through the decanting process. We'd rather not have to go through the state modification of arrangements in order to make that happen. When you can anticipate that in advance, that's usually the best way to be able to take care of the arrangement. All right, let's clean up our wine glasses here and take a little bit of a look at the two different kinds of special needs trusts that we'll focus on here, and how to identify what type of trust is appropriate. So the key question is, whose money is it, right? Is it the child's money? Is it the subject, let's say, of the assets, or is it another? Okay, this is where it's a third party arrangement. Okay, if it's the subject themselves, it's a first party arrangement. And then what is the source of the funds? Is it inheritance? Is it outright? Is it in trust? Can we get to it before it actually makes that distribution? Or is it some kind of a personal injury or medical malpractice type of arrangement? Sometimes they refer to that as med mal. Nobody can actually say the entire word. That would just be working too hard in a society where we have to do everything in less than 140 characters, right? So medical malpractice situations or personal injury situations where it's coming from some other third party. Again, I would want to, the judge should anticipate that and help you to set up the most appropriate arrangement for the beneficiaries. But sometimes the family will have to encourage that to make sure that it's set up from the beginning as if it's behind the wall and not the child's own money. In a lot of the complexity of some of those cases, some of the money is treated as the child's money, other money is treated as money for benefit of the family, and the difficulties that they'll have and the expenses that they'll incur as a result of that. And so sometimes those decisions are bifurcated within those arrangements. So if I've got a first party special needs trust, again, this is my money for my own benefit. The key thing is, would the beneficiary have control of possession of the funds, right? That's the element of this. Do I already have those funds? Am I inheriting those funds directly? Am I named just outright as a beneficiary of a life insurance policy or something like that, where funds are coming into my own name? Initially, federal law required that first party special needs trust had to be established by a parent or grandparent or court or guardian, right? That there's some arrangement where somebody who was in legal charge of this ward, let's call them, subject of the arrangement, and they limited who could create that arrangement. But there was National Academy of Elder Law attorneys lobbied for a change to that rule and amended to allow individual beneficiary to establish a self-settled special needs trust rather than have somebody else do it for them. Because I might be perfectly mentally competent, fully able to manage my own affairs, and nonetheless have money that is there available on my behalf. And so it's important that I can create a self-settled special needs trust. Generally speaking, you can't take assets of yours and set them aside in an irrevocable trust and protect your assets from your own creditors, especially if you can still be a beneficiary of those underlying assets, right? So this is something there's huge firewalls in state law to try to protect against, usually at least 5-year outlive periods and those kinds of things put in place to try to discourage those kinds of arrangements from being set up and taking money that would otherwise be available that would save the state the money of having to pay that money out and putting it down instead. The key thing to understand about first party special needs trusts is that there's a mandatory payback provision, what some people call a clawback provision upon the death of the beneficiary. Okay, so here is my self-settled special needs trust over here, a first party trust, and it has X amount of dollars in it. Over time, let's say that the state or federal programs, let's say the state programs through Medicaid, has been paying my bills. Or my medical care. So they're keeping track of what the total amount is they've expended over a period of time. And at death, obviously, they're going to, or the termination of the arrangement, they're going to look over here and go, hey, are there any other assets that are now available? We don't need to supplement the needs of the child anymore. The child did have some assets of their own that they set aside and used for appropriate purposes during that period of time. Nonetheless, if there's a remaining balance, right, they only used part of that up during the child's lifetime, and there's still money available in that fund to the extent of the state's expenditures on behalf of that child, they can tap into those funds. Okay, so that's one of the distinctive things about a special needs trust when it's created in a first party standpoint to understand the big distinction between the two. Outside of that, expenditure-wise and everything else, the rules work pretty much the same. But from a ownership standpoint, obviously that's quite a different arrangement versus a third-party special needs trust, so where the funds were never in the possession of the control of the beneficiary. And we say possession or control because it's not just outright disposition. What if I created an irrevocable trust and gave the child the ability to tap into those resources under a lifetime general power appointment, which would be non-restrictive, or even under a broadly drafted limited power of appointment? Again, as I said, if medical care is one of the things that is allowed as a distribution standard out of the trust, the trustee can't much say, well, there's medical care going on, but we don't want to pay those bills, right? The court would look at that and say, well, the intent of the grantor clearly was to pay medical bills. They said it right there in that paragraph. And so this is why you have to be careful with language that's being used inside the trust, whether it was intended to be a special needs trust or whether it was not intended for that purpose. So the funds can never be in possession or control of the beneficiary. In possession or control of the beneficiary would mean it's a first party creation instead. They're established by someone other than the beneficiary. So this is where our third party reference comes to. Somebody other than the beneficiary is the one creating this arrangement. And you can do this during life or at death. Obviously, if you have a child that you know is in a special needs situation, people will very often create that trust during their lifetime and begin gifting to it and funding that trust over a period of time. If they have lots and lots of money, they might go ahead and fully fund that trust with the assets they believe will be necessary for that child in their care. Again, from that point on, if it's an irrevocable trust, I've given the assets away. All the growth on those underlying assets would be out of my estate for estate tax purposes. So creating this in an inter vivos fashion for people who have more money than they need to live on for the rest of their lives, right? That's really the key criteria. How much money do I need to live for my lifetime needs? And it's a very simple question to ask people. How much money do you need to live on comfortably for the rest of your life? If they say $10 million and they're worth $15 million, I'd say great. And who does the other 5 belong to? Right. So from a functional standpoint, that's where you have excess wealth. And that excess wealth, right? I'm just getting them into mental state to understand. Maybe we want to put that into a separate pot, right? This is where I can gift. This is where I can be irrevocable. This is where I can transfer those assets away during my lifetime and know that it's not going to affect my own lifestyle. But in fact, the answer for a lot of people might be, I'm just making numbers, that's round numbers, 10. And in fact, they're worth 3, right? So from a functional standpoint, obviously, they haven't gotten to this number yet. So that person's much less likely to transfer, gift, or make irrevocable transfers during their lifetime. You're probably talking about a testamentary creation of an arrangement in this case, and whether that's going to be in their will, that's going to be in their trust, it's going to be in some other device that is going to create this after the death of the individual instead of having that set up on a current basis. And there's nothing scientific about that questioning process, obviously. What you're trying to do is get the person into the frame of mind who has substantial assets of this is how much I need to keep control over. So that capital lifetime needs are the things that they would keep total control of. This is the stuff that they would have in their own investment portfolio. This is the stuff that they would have in their revocable living trust, the things that they're going to have complete control over, their residence, their retirement accounts, et cetera. And of course, for the average American, most of us can't afford to give away any of the assets we have. We're working very hard to build up enough assets over the course of our lifetime to be able to live on for the rest of our lives, presumably spend down. Our biggest fear is not running out of money before we pass away, or having enough money to be able to sustain our lifestyles through that period of time. And so that's the big distinction about whether this is generally going to be created inter vivos or in a testamentary capacity. The other question about the inter vivos is when there is a settlement or other arrangement, which of the monies are not considered to be the beneficiary's own monies? Can those monies be put directly into a special needs trust and be treated in a third party fashion? That's a good thing to bring up in the courts to make sure that as the judgment comes down, the judge does have some latitude with regard to how the money is assigned. And so that is important for us to understand and sometimes bring into the conversation early on. But this is where there's no payback provision required. Again, the money was never the child's in the first place. So if I put the money into an irrevocable trust for benefit of the child, and I've got my asset protection, tax protection firewall between the two, this isn't the money's child, the child's money. They may be a distributee. They may be the only current potential distributee of assets inside of that trust. But with the right language, I can make sure that this is not subject to their creditors. It is not subject to that clawback at death. That's the critical difference between third party and first party special needs trusts. And so the structure, the arrangement as it's set up, very, very important to understand how that piece is done. So here the grantor or testator directs the ultimate disposition of the funds on the death of the beneficiary. Very important, if the trust is not exhausted by the time the beneficiary passes away, where are the remaining assets going to go? And that can be obviously to other individuals. It could be on to charity. I've seen lots of these where they're set up and then they go to the foundation or whatever organization is researching the disease or issue that the child had. So sometimes they have charitable remainder aspects of it. They can't be traditional charitable remainder trust because those require distribution of a certain amount of money and will oftentimes disqualify the child from benefits for the arrangement. So a diagram that we have looked at in the past with that special needs trust on one side of our asset protection firewall here. Certainly also estate tax protection, but that's not so much the point here. In situations where there are substantial assets built up and available to the child, that can be an issue as well. But here we'll focus really on the asset protection side of it, because you're just trying to figure out if this is going to be available to the child without being available to the state. State is a provider, for instance, of medical care, right? Looking at the care programs that are available. So you can distribute in accordance with the client's wishes and the trust's terms. And so this is where the trust terms become really important. And those terms can be adjusted using powers inside of the trust. The trust may have the ability to modify the distribution terms associated with the trust. If they don't, I might want to, rather than go through the state's modification process, but doesn't meet some of those, you can have judicial and non-judicial modification in a lot of states. So we can alter the language of the trust going forward, or we could decant that trust into something else. So I descant it from a non-special needs trust into a special needs trust. Again, I created a regular, irrevocable, complex trust for benefit of my family. That doesn't meet the needs of all of those family members. So maybe for that one beneficiary share, a decanting takes place into a separate trust, right? If you can distribute outright to Daniel, then you can distribute into a trust for benefit of Daniel. That's the concept that drives the decanting process. So the terms can be adjusted. You can create tax protection, obviously in a first party trust. This would be in their estate for estate tax purposes. And you're going to be subject to the clawback provisions under state law. Whereas in a third party trust, it is not going to be in their estate as long as the powers, usually these are very restrictive with regard to distributions. And so that makes them much more protected from estate tax, right? Even just a regular, very broad, if I used a independent party like National Advisors Trust Company as the trustee of the trust, then I can say, as the trustee deems appropriate, and that is considered to be an acceptable standard because I have an independent trustee. But if I'm using family members or there's conflicted parties involved or controlled parties involved, I need to use very specific language, and that's why the code specifically says things like health, education, support, and maintenance, right? It gives us some examples of the type of terminology that would be okay to use. So third-party trust would not be includable in the estate and does not have the clawback provisions. Now, I would say, as I mentioned before, that for asset protection purposes, they're pretty much the same. During the lifetime of the child, these should both be protected arrangements. Certainly, if push comes to shove and there was an issue where the child created liability or something like that, the first party trust would be much more subject to that. The third party trust is the most protected arrangement that you can have. But from an asset protection standpoint, we're talking about state, federal aid programs. They should work in a very similar way for asset protection purposes. And one of the key things, of course, is it provides asset management. That's why we got into the conversation in the first place a lot of times. All right, there's assets that need to be managed. We just need to have it in a particular structure in order to be able to benefit the particular family that we're trying to help. So asset management is a key part of that process. Certainly, we don't want to just talk about the structure without the fact that you're getting professional asset management in the process of doing this. And this becomes an asset location issue as well. Sometimes not all of the assets will go inside of this arrangement, but it is important to consider exactly how that's going to work and how that's going to work with regard to the beneficiaries. And just a side note, I've had client situations where a client has a long-time loyal employee, and they're certainly not in a special needs situation, but they might have a low income, right? They have a low skill threshold or whatever. And so even though they're providing care services in a non-professional manner, meaning they're not degreed in that area, right? They're just helping me around the house and I pay them to do that. And I really appreciate what they've done for me. I had one client who was doing exactly that. And so when we were redrafting her estate plan, she wanted to make sure to take care of this woman who had been very loyal to her and worked for her throughout a very long period of time. Well, having met that woman before, I said, well, is it okay with you if we involve her in that conversation? Because I had this little inkling in the back of my mind, there might be a potential problem here. And sure enough, when we brought it up, you think this is be counterintuitive. When we brought it up to the caretaker, she said, oh, no, don't do that, right? You would disqualify me from my aid programs that I get from the state. If she earns over a certain amount of income, then she would disqualify under the state standards for distribution. So unless it was going to be a huge amount of money, hey, leave me 10 million, maybe I'm good. But if you leave me $100,000, that can be problematic actually in a case like that, where somebody is dependent on that ongoing inflow because they had their own money and then ran out. There might be a period of time where they're disqualified from the programs. So that's an important thing to look at even when you're not dealing with a special needs situation. So these are some things for those of us who don't administer these on a day-to-day basis. It's kind of nice to have some idea of what kinds of things special needs trust can pay for without worry. The kinds of stuff that has been approved by the government says these are the kinds of things that you need. So an automobile or van, generally one vehicle, is where you have to be careful, right? We're not buying a fleet of cars. We're not buying a Jay Leno garage kind of antique special automobile kind of stuff, but an automobile or van for transportation. Usually these can be geared out with all the equipment that's necessary. If I'm in a wheelchair, for instance, where I have to have special lifts or the kinds of things to be able to transport me or get me in or out of the van. You also have to look at the capabilities of the people around you, because if I don't have a caretaker who can lift me, for instance, and I need to have that, then I would need some kind of mechanical way to be able to do for that stuff. Most of the stuff is pretty straightforward: accounting procedures, acupuncture, acupressure, certain kinds of appliances, right? Just basic appliances of life, things going to help make life easier for me. Obviously, federal aid programs, state aid programs are not going to pay for those things. They're paying for medical procedures. So this is where you really start understanding what supplemental needs means. There's a lot of things that might make my life easier or more comfortable, but that are not paid for by those programs. They're not going to buy me an iPad, right? But I might want to have an iPad, and that might be a good way of entertaining that individual, or a way of doing research, and something that would be easy for them to be able to handle in their state. Bottled water, water service, bus passes, right? Public transportation costs certainly would be covered by that kind of thing. Cameras, films, recorders, tapes, film development within reason for the kinds of things that you and I would want to take pictures of, family and holidays and those kinds of things. Clothing, clubs and club dues. We have to watch for what kinds of clubs, obviously, those are, but certainly if I want to belong to a library or the zoo or whatever, museums, and those are things that would keep me properly entertained, not culturally enriching, but not personally enriching, obviously. Computer hardware, software programs, internet service, those kind of things certainly should be available. Conferences related to areas of knowledge that I have, or diseases or other health issues that I address. Basic things like cosmetics, courses, classes, curtains, blinds, drapes, dental work not covered by Medicaid, so anesthesia, stuff like that. Also would be covered by that. Down payments on a home or security deposit on an apartment. The government wants you to be self-sufficient, otherwise they're going to have to take care of you. So again, all of these things are very carefully planned to try to identify how can we create essentially a public-private partnership here and make sure that the person is properly taken care of. So you can read through that list of things and just identify some of the key elements of what would be available to those individuals. And some of those things surprise people, and some of those things are, I think, very, very obvious to people. Massage is a critical thing for a lot of people, especially if I have a disability or an issue that causes me to cramp up. It's a critical element of the process, where some people might think of that as a luxury. In fact, it's a necessity. In fact, it's a medical expense. And in fact, for a lot of people to be able to have that done, it might be able to be paid for by federal aid programs, but it may also just be something that makes me more comfortable in what I'm doing. So some of the other elements that go along with that, even pets, right? That can be a very soothing thing. Certainly therapy and tuition and those kinds of things are all available for people. What should the Special Needs Trust not pay? As we come to a close here and look at some of the other things that are out there, no cash to the beneficiary, right? Bills should be paid directly to the service provider wherever possible. I'm going to give you a little link to something in a second that can help with some of that. No items provided by government programs. And when a trustee buys items and things that are countable items, that is, say, things that might be treated as money for the beneficiary, there are thresholds that you can stay within. There's always a danger that $2,000 limit will be exceeded. So very specific questions should lead to the program operations manual system, and the government has some very specific systems for that. You can go in there and kind of search through that, see an idea of what's there. One of the things that is used a lot in trust administration is what they call a TrueLink prepaid Visa card. This way, sometimes the beneficiary can spend the money themselves. So the trust beneficiary basically is the card holder of that card, and we simply restrict what the card can be used for. So we have the ability inside of these things to control spending according to the needs of the beneficiaries. There's real-time control. You can toggle on and off what is allowed to have expenditures of. So you can find that at truelinkfinancial.com. Here's an example of what one of those spending screens might look like. You know, you can pay for automobile repairs, but not necessarily beauty devices, right? So these are the kinds of things that might cause problems within that arrangement. This is one of the ways that people restrict the spending even of their children, right? Child's out of college, and I want to be able to put one of these kinds of cards into place. But they're very useful, obviously, in a case like this, to be able to limit to things that we know would be acceptable expenditures associated with that individual. So certainly special needs trusts and their beneficiaries are special people to take care of. And therefore we need to use specialized resources, attorneys, CPAs, trustees, caregivers, case managers, all the people who specialize in working with this group of individuals within the attorney CPA marketplace, finding people who really specialize in some of these areas. They're very often professionals who have their own special needs family members, somebody that they are caring for, and therefore gained a lot of interest and insight and expertise in these specific areas. So be aware of the rules, make sure to ask the questions. Most people with special needs trusts don't have a trust in place. That's just a statistical reality. And so it's important to make sure to ask the questions and help people to understand that there are resources that can be made available and ways to be able to protect the inheritance that is coming from children. And also just make sure that within their estate plan, inadvertently, that no inappropriate distributions are made, right? Sometimes we forget to make changes to things like beneficiary designations inside of retirement plans or life insurance policies, right? Not just the traditional will and trust documents that are out there. So I'll turn things back over to Kurt at this point. You can see in the back, there are some resources available to you and some links to special articles in that area. Anything that we can help you with in that manner. We do have a 2-day special needs school that we run at Canon. If you have a need for in-depth information about this, we would be happy to help you with that as well. So with that, Kurt, I will turn it back over to you.
Thank you very much, Daniel. We will now open up the chat box for any final questions you may have for Daniel. Feel free to submit them in the chat box now if you have not already done so. While we wait for questions, I want to remind everyone that a recording of the presentation today and recordings of all of our presentations will be available on NATC's YouTube channel. You can expect to see this presentation uploaded there in the next day or so. Also, if you joined late, I want to remind you that following the webinar today, you will receive an email that will instruct you how to report your CE credits for attending. And that email will also include a PDF of today's presentation slide. If this was your first webinar of ours that you attended today, welcome. I hope you enjoyed it and gained value from it. You'll receive an email that will ask you to take a survey. If you would, please take a minute or two to complete that. We would love to get your continued feedback on these trust education webinars. So again, if any of you have any questions, feel free to submit them in the chat box now. Question, will the slides be available? Yes, they will. Another question, Daniel, are there any issues or restrictions on funding an ABLE account from the Special Needs Trust?
Generally speaking, you can do that. ABLE accounts are also protected arrangements. And so ABLE accounts are a nice way to be able to approach this as like a 529 plan in effect. For benefit of the child and has certain funding requirements. It just has to be an acceptable distribution from the trust. But as a general rule, again, you have to check with your state law. You can fund ABLE accounts from a special needs trust, or sometimes even another kind of trust. You might be funding an ABLE account instead of a special needs trust. In certain cases, maybe there's not enough money to make sense to have an independent special needs trust that you would create.
Okay, well, I don't see any other questions. Thank you, Daniel, and thank you all for joining us today. Please feel free to reach out to Daniel or me with any follow-up questions, and have a wonderful rest of your day and happy holidays. Thanks, everyone.